Hello, I'm Sagar Rage, owner of Rage Law, a premier business law firm that serves our clients in Nevada, California, and other states. I'd like to chat with you today about mergers and acquisitions. I'd like to talk to you about what they mean, what you can expect if you are either going through or thinking about pursuing a merger or acquisition, and a brief overview of what the legal process could be in your matter. Mergers and acquisitions are more and more common nowadays, as I'm sure you're aware. It's a very quick way for a business to grow, to add on to different revenue streams and different services that are in goods that they might not be currently providing, to grow customer base, or just to get more market share. Mergers and acquisitions are very, very important in a business setting, as I'm sure you know, because they really provide for the ability to bolt on certain revenue and profit streams. Mergers and acquisitions are a little bit complicated in nature depending on the industry they're in, depending on if there's specific licensing, such as gaming merger acquisition versus a merger regarding insurance companies versus banking and so on. It's very, very important to really follow a general legal pathway that makes sense to have as smooth a transition as possible from your current structure to the structure that you end up being after you merge or you acquire a company. It's very important to have a law firm that understands the process. The process really starts with an initial assessment. The reasoning for the merger or the acquisition should be pretty clear with the management team. And the initial assessment really is going to be a little bit of the due diligence that goes through. So whether that is some sort of an LOI or letter of intent that's signed before some of the documents are shared, financials are shared, and so on. But the initial assessment is really a way to figure out if the merger or acquisition does make sense for your business. After that, some of the most common question I get asked is, okay, great, if we want to buy it, we think it'll be useful. The next question I get is, okay, how much should we pay? That's where the valuation really comes in handy. It's very important to have experts and other people that are very good at evaluating the business you're seeking to merge with or acquire, and really kind of hone in on what the fair value would be. It's very rare to have a merger acquisition where the value is significantly different than the market rate. Generally, there will be a range that is acceptable, whether that's for any kind of loans and covenants and debt covenants and other things that are needed, or it's just simply what the seller would want. And if you are a seller, this applies to you on the other side as well, that you'd want a fair value for your business. You're not going to take a lowball offer, and the buyer's not going to pay you significantly over the market. In that process, that's where the negotiation comes in, and the attorneys would kind of jump in and negotiate and with the other side and really come to a number that really makes sense. In addition to the valuation, there might be other considerations, right? So a buyer or a seller or two entities that want to merge might have other considerations of, okay, who's going to be the management, what's going to be the management team of the new entity, right? Are we going to mix and merge? Are we going to get rid of some departments? Are we going to merge departments? Are there synergies that we're going to benefit from when we do that? All of these other things are going to be other terms that would need to be ironed out between the parties. And it's going to be the lawyer's job to really kind of hone in on those, to figure out which ones to really push on, which ones that you could live with, and really to put them in a contract to make sure that the contract reflects what the parties believe their understanding is. If the business is a specific type of business that might need a regulatory approval from either a federal, a state, or local agency, those need to be undertaken in due time as well. You want to make sure that those are done correctly. You don't want to delay a merger or acquisition because something didn't get filed correctly. It's very important also to not just realize, okay, here's what we want to buy, here's how much we want to pay, and here are the other terms, but also what happens after the fact. And I think from my experience, I've seen a lot of gaps in both management teams and on the attorney side, where there's really not a lot of thought to what happens after. Okay, we buy it, then what? And a lot of those things, what happens after the purchase, will, believe it or not, govern and guide us in what we want to do today, right? So let me give you an example. If there is an acquisition and there is a down payment to be paid, a good faith payment, earnest money deposit, what happens if there's closing and there's substantial funds owed? let's say $2 million is owed after the purchase, and that needs to be paid off. What if there are issues that are found in the business? Can you offset those with the note, with the $2 million that's owed? What happens? Who's damaged? What happens if one party's not happy with the purchase? What happens if the other party doesn't get paid on time? What happens if payments aren't coming through on time? What happens if there are assets that are the collateral that's there in the deal? What if that goes away? What if there's a bankruptcy? What if there's death? All of these things kind of need to be thought about, not just during the closing and during the process of acquiring the business, but also after. And a lot of that will govern what you do today. So it's very, very important to have an attorney that understands that process and that kind of walk you through that process and give you examples of, hey, here's what I've seen happen, here's what could happen, but really it's your decision to make. Here's the risk, here's the choices, here's what I would recommend, but at the end of the day, it's going to be the client's decision. So it's very, very important to have a merger and acquisition attorney that understands what these merger and acquisitions are, that has taken significant parts in these type of matters before, and that can advise you and govern you. And the lawyer's job in merger and acquisition cases is not just to draft up a contract. It's a lot more. And some clients say, look, we only want the contract, which is fine. That's not a problem at all. But a lot of times a lawyer can be significantly more effective if they're involved from the beginning to the end, so that it benefits the clients the most. I hope the video today was a little bit useful and a brief guide as to some of the issues and some of the paths and some of the checkpoints that you'll have to hit from beginning to end in the merger or acquisition process. If you're a buyer or a seller of a business and you'd like to chat a little bit more about a potential merger or acquisition, please feel free to give our office a call. It's a free consultation. We'll be happy to chat with you. You can reach us at 702-758-4240, or you can visit us online at www.raichatourneys.com. That's RAICHATTORNEYS.com. Thank you so much, and I look forward to hearing from you soon.